Welcome to the Anson's Law podcast. Today I'm joined by my colleague Victoria Ramshaw, who is a solicitor in our employment department, and we're going to discuss some recent developments which seem to vastly increase the scope of discrimination law in the workplace. Good morning, Victoria. How are you?
I'm good, thank you. How are you?
Yeah, very good. And I'm interested to learn that something that hadn't realised, and I imagine quite a few of our viewers won't have realised, that over the last couple of years, both in terms of legislation and case law, discrimination law and who can potentially bring a claim has vastly expanded. It
has. It seems to have gone under the radar a little bit. It started off with a case in the European courts nearly 10 years ago.
Okay.
And it only recently seems to have actually sort of made its way into our case law. And then it's been actually codified into the Equality Act. And
an amendment to the Equality Act.
An amendment to the Equality Act.
Okay, so let's start off from the beginning. We were discussing this on the car on the way over. We started to have sort of anti-discrimination legislation as early as the sort of mid-1960s. Race Discrimination Act came in. There was followed sort of about 10 years later or so, mid-70s, by
so
the
75 was the Sex Discrimination
Act. And broadly speaking, what the law is looking to do, which I think is an uncontroversial thing, is to ensure that people aren't discriminated against as a result of a characteristic that they have got, such as race, such as their gender, and to ensure that the law protects them, because I think it's probably uncontroversial that you shouldn't be denied a job opportunity or a pay rise or anything really just because of your gender or your sex or anything else. Yeah,
and it's also goods and services as well. It's the full range of discrimination. So there was a case, was there not, about a bakery that wouldn't bake a cake for a gay wedding. That I remember was in the news sort of 10, 15 years ago or so. Broadly speaking, discrimination protects people, and I know that this is part of what we're going to discuss today, but it protects people with protected characteristics. So what are the protected characteristics that we're talking about here? So obviously you said it started off with race, the sex. You've got sexual orientation and gender reassignment, which is quite...
Transgender,
so that's quite prevalent recently. But you've also got disability and age, pregnancy and maternity as well. I think I've covered all of those.
You've virtually got them all there, I'm sure. And I was remembering as ever, I did quite a lot more employment law in the early part of my career than I did now. So my career sort of starts at the beginning of the century, right, which makes me sound older, I think, than I am. But at that point, each year or each couple of years, it seemed to be that there would be a different regulation that would expand the different types of the different protected characteristics that it would protect. I mean, definitely religion came in that period because religion wasn't previously a protected characteristic.
So those weren't our UK statutes. They were just European regulations that expanded to religion and belief, and sexual orientation as well as age. So we already had a Sex Discrimination Act, we had a Race Relations Act, and we had some legislation to protect people with disabilities. But the European regulations then expanded that even further. Yeah.
And then that culminated in sort of quite a sort of mammoth piece of legislation, which it's a piece of legislation which in some respects I don't think particularly changed the law, but brought it all into one piece of legislation and tried to make it consistent between the different characteristics, which was Equality Act 2010.
Yes.
And indeed,
so I think I looked it up. It said it was 116 pieces of legislation that it brought into one act, and they're all essentially doing the same things, but it's consolidated them for the protected characteristics, which have expanded over time. But it's the same rules in relation to each, except some slight changes for age discrimination and some different rules in relation to disability as well.
And so that's the protected characteristic that you need to have to bring the claim. Although we're going to come on to that, I get that. We're going to come on to that, but at least traditionally that you needed to have to be able to bring a discrimination claim. But then discrimination itself can take two forms, really. Yeah. Direct and indirect. Now, the most common that I think we would all accept is direct discrimination. I'm not giving you a job because of the colour of your skin or your race or your religion or the fact that you are your sexual orientation. I'm not employing anyone with that. And if I've denied you a job on that basis, that's got to be what direct discrimination is.
So direct discrimination is if you treat someone less favourably because of their protected characteristic. So it's exactly as you say, it's if you don't give someone a job because they have that protected characteristic. Or
I went into the example, you gave me some legislative language there, which is what I would expect from a lawyer, which is good. But indirect is a little bit more of a nebulous concept to me.
Yeah. So that's where there's a provision, criterion or practice that puts someone with a protected characteristic or a group with a protected characteristic at a particular disadvantage compared to those that don't have that protected characteristic. So that sounds like a bit of jargon, but essentially if an employer has a policy in place and if you've got a certain protected characteristic from that list, you struggle to comply with it or it's going to put you in financial hardship or something like that.
So this would be, you could, one of the common ones there is, for example, anything, and I know it's become its own characteristic too, but something that made life in the workplace more difficult for a part-time worker. Yeah. Strictly, and normally I think this remains the case, that you're more likely to be a part-time worker if you are female. Yeah. So if you had some sort of practice that didn't allow access to a bonus or just made life more difficult for somebody who was more likely to work part-time, then that's likely to be indirectly discrimination against women.
Yeah, if they've got a policy of not providing bonuses to someone who works part-time or works less than a certain amount of hours a week, then that has the potential to be indirectly discriminatory against, as you say, women, because statistically part-time workers are more likely to be women. That's kind of similar to the case of Dobson, which one of the ones when you're studying. When I was studying,
go on, tell me about the case of Dobson.
Dobson against British Airways.
Go on, give me the year of that one.
I'll have to find the year.
That's okay, but it's going to be one that's post 1999, is it?
It is, yes.
And the precise year I didn't need to know, but go on. What was the facts in that case?
So the employer imposed a change in schedules. Right. So a change in shift pattern. They required all of their workers, or all of their employees, to work evenings and weekends because they wanted flexibility from everyone. Yeah. So Mrs. Dobson brought a claim because she had childcare responsibilities and finding childcare to fit with this new flexible schedule, it was going to be difficult for her. It also put her at an additional cost. Yeah. So that was found to be indirectly discriminatory.
And because her. She indirectly, because in her position as a because women are more likely to have those childcare responsibilities still that remains the case in society, and because it did have that consequence on her. That was a detriment that she was suffering, but also detriment that potentially the class of employees or with that personal characteristic, i.e. women, were likely to have. Yeah. That's where we've got.
But the policy was applied as a whole, so it was applied to everybody, but because of her being having these childcare responsibilities and it being more likely that she's going to struggle to comply with that, and women in general are going to struggle to comply with that, then it becomes indirect discrimination because there's the policy in place, and then
yes, as opposed to the direct discrimination when you're literally going out singling one person
because you're a woman. we're going to make you do these hours.
Yeah, if she was the only woman on that shift, and they almost knew that she wasn't going to be able to make the change, there's an argument that it could have been run as a direct discrimination case, presumably. But that's a relatively extreme example.
Yeah.
Okay, so in terms of in terms of the expansion, which is what we're going to discuss today, we're going back to the Equality Act, which is codifying all of that legislation. And in some respects, codifying European legislation. We have got, running the way through the European courts, the ECJ, I think it's important to distinguish, which is an EU court, as opposed to the ECHR, which is a completely different court, which deals with completely different things. But in the ECJ, we've got different cases which are running their way through, one of which vastly expands the scope of indirect discrimination. Can you talk me through what happens?
So there was a case in Bulgaria.
Okay.
The events were around, I believe, 2015, and the case came to a head in 2016.
It's got a really difficult to pronounce name, but it's nicely been shortened, hasn't it, for sort of English speakers, and it's known...
it's the Ches case, but it's the case of... Mrs. Nikolova.
Okay, we can cope with that. Mrs. Nikolova. So what had happened to Mrs. Nikolova?
So she lived in an area in Bulgaria that was predominantly occupied by Bulgarians of Roma descent. Mm-hmm. So that was distinguished as a race. Because of it
is in this country too, right?
Yeah. So, because I've got that national heritage and that background, she was not of Roma descent, but within these Roma, predominantly Roma communities, the respondent, the electricity supplier in this case, were putting their electricity meters at a height of 6 or 7 meters above the ground. So,
okay, and I'm not quite sure where this is going now. Okay.
Yep. So what that meant was people in the area couldn't check their meter readings. They couldn't check whether they were being overcharged for their electricity. They couldn't provide updated meter readings. They couldn't check whether the price per kilowatt was correct because they were so high off the ground.
Have we got any idea why they were doing this, by the way? Is this like blatant discrimination? They were doing it to make life more difficult for them?
They were doing it because they believed that there was tampering with the meters in those particular areas. So it was that belief that people of that descent
were more likely to fiddle with the meters.
To tamper with the meters.
Right.
In other areas, they had the meters at a height of, I think it was 1.7 meters off the ground. So most people can access that.
Could you access that?
If I had a little step.
I was going to say.
I'd be fine.
Let's not use this video as sort of evidence of me discriminating. Or I guess it would be harassment strictly, but yes. And shortness is not a protected characteristic, I don't think, so we're all good. No. And we're going to come on to that.
Yeah.
So we've got these meters that they're worried, the authorities are worried about Roma people being more likely to tamper with the meters, so they put them up in the sky. Presumably at a height that perhaps only people with their van and the step ladder from the
or a cherry picker or something, so
check.
Only they could really check it. So the people within the area brought a claim that policy of having the meters at such a height in those areas was indirectly discriminatory on the basis of race.
Okay,
and they were successful.
Okay,
however.
Mrs.
Nikolova was not of Roma descent, so technically she didn't have the protected characteristic. So in theory, she couldn't bring a claim, even though she was also suffering this same disadvantage.
Yeah, it seems a bit unfair, right?
Yeah. So that's what the courts decided. They said the purpose of the law isn't to only benefit the people that have a protected characteristic. They have to also protect people that are suffering the disadvantage if it's because of that protected characteristic.
So if they're discriminating against people with the directly or indirectly, or in this case indirectly, against the people with the characteristic, but it harms other people who haven't got the characteristic, they get the benefit of the protection of the law too.
Yeah. So it expands it essentially. So you no longer have to have the protected characteristic. You just have to show that you've suffered the same disadvantage. So in this case, there'd already been a case, and essentially Mrs. Nikolova needed to join that case as a claimant, or bring her own case alongside it, and she was allowed to do so.
And it went, but it had to go right the way up to the ECJ for that to be determined.
Yeah.
I mean, on one level, actually, I can see how conceptually, on one level, when the scope of discrimination law is being expanded, we will get lots of people say, this is this is woke, or political correctness gone mad was the phrase that was used when I was younger, but that it's too woke would be now. On one level, actually, and I get that this has come from European courts and people have a certain view on that, but there's a certain fairness to this. This is making sure that it's not just people with that characteristic. It strikes me that Mrs. Nikolova should be allowed to bring, shouldn't suffer from having a meter that's 10 foot in the air or whatever it was.
So it's making sure that everyone is actually treated the same. So you wouldn't have just her meter left at 6 or 7 meters and everybody else is moved back down to 1.7. It just made sense that obviously if she's suffered a disadvantage because they've got this policy that is found to be discriminatory, well, why shouldn't she be able to bring a claim? I
100% get it, but us lawyers are going to law, right? So I can see that there is some potential massive unintended consequences. Yeah. Well, maybe they're intending consequences, but once the lawyers across Europe, and particularly in England, are reading this, there's if you can bring a discrimination claim and you haven't got the protected characteristic, that is expanding indirect discrimination. Now,
so this was just in relation to goods and services, actually.
Right.
Specifically, the case was, but it seems to have applied more broadly.
So go on. We get to.
This was 10 years ago. That case.
Yes. Yeah. But and then it's presumably there's a little bit of reporting or whatever. Yeah. Maybe it's gone unnoticed. Maybe it hasn't. But setting aside what was done in terms of legislation catching up with that case, we get an English case, don't we, on the subject in the last summer.
So last summer it went to the Employment Appeal Tribunal, but the actual event started in 2021. So it's following on from COVID.
Right.
So it's the case of British Airways v. Rollerton and others.
The airline.
Yeah. So British Airways, after COVID, made significant changes to their schedules,
right,
which affected shift patterns. So again, we're seeing the same example as before. Change in shift patterns has the potential to affect people with the protected characteristic of sex.
Yeah.
But also, because this related to cabin crew that were working from Heathrow Airport, there were actually people that were commuting from abroad.
Yes, I seem to remember there was a number of people that were the people like even as far as like Dublin, but they were
France. Yeah. There were people as far as France as well. Yeah. So that potentially meant that they were going to struggle to comply. There might be additional costs in having to try and comply with those
because the shift patterns was changed and they were at different times, perhaps when it was harder to get to the get to the airport. So it wasn't just about sort of people with parenting responsibilities.
No. So there were essentially two types of indirect discrimination here. There was indirect discrimination on the basis of sex with the childcare that we've already discussed, and indirect discrimination based on race, because those from abroad were more likely to be non-British nationals.
Okay.
So so people who were British nationals that lived in the area
was
around
it race
Heathrow,
or was it nationality, or is that how race nationality falls into the race as a protected characteristic?
Yeah, so race is the name of the protected characteristic and it deals with nationality, ethnic origin, national origin as well.
Yeah, and presumably actually includes what we were discussing earlier in terms of like Roma identity and that sort of thing. So they want to introduce these changes post-COVID. They're changing all the schedules to try and see if they can start to make some money again. Having lost a load of money for a period of time, and they want to introduce the shift patterns, and then a number of people, presumably union-led, starts to challenge this in the courts.
Yeah, so they challenged it. Obviously, the people that did have the protected characteristics challenged it, but there were also challenges made by a couple of other employees. So we've got Mrs. Kerr and also Mr. Pettinella.
Okay, so, Mr. Pettinella. Am I going to be indirectly discriminatory to say that is Mr. Pettinella? Is he coming in from France?
So no.
Okay, fine. Right, I'm going to shut up now. I'm going to get myself into trouble here. So
Mr. Pettinella brought a claim that he was also being indirectly discriminated against because he was suffering the same disadvantage as women, because he also had caring responsibilities and would struggle to comply with these changes.
But strictly, Mr. Pettinella didn't have any protected characteristic that generally you'd be able to bring a claim on this basis, but save that he could say, well, I've got the caring responsibilities.
Yeah. So the protected characteristic in this case would be sex, but it would be specifically being a woman, because of that statistically you're more likely to have caring responsibilities if you're a woman. So he suffered the same disadvantage, even though he was not a woman.
Yeah, but this, again, I think a lot of people would say, well, that kind of makes sense, right? He's also suffering the detriment. It's just like Mrs. Nikolova in a 10-foot metre above a house. He's suffering it too. He's got caring responsibilities too. Yeah. He should be able to bring a claim. What about Mrs. Kerr?
So Mrs. Kerr lived in France, but she was a British national. So she did not have the protected characteristic of race, because she was a British national. So in theory, the other British nationals were living locally. They weren't affected by these changes, or not in the same way. So she brought an indirect discrimination claim on the basis that she was suffering the same disadvantage as the non-British nationals that were living abroad.
Right. So, and again, same as the 10-foot metre, right? She's just suffering just as much. She was living in France,
just like the other employees that were living over in France. She was going to struggle to comply with these changes.
And the way that English law applies, the decisions of the ECJ are sort of binding precedent. We've got a common law system, which means that what's been decided in previous cases becomes part of our law, if you like, or part of our body of law, even though it's arguably a foreign court, but it's a foreign court at least until 2021 that we agreed in legislation that we would accept their rulings, and it got sort of superiority over our courts. So in effect, they are using Mrs. Nikolova's case as precedent to make that decision under English law, right?
Yeah, so the tribunal had to consider whether they had to read the law in compliance with EU law, and because the case was it's pre-Brexit, not just it's a pre-Brexit vote,
right? Let
alone pre-Brexit. So all the way up until we actually left the EU, that law had to be incorporated into our legislation. So things like the working time regulations, we didn't have a separate law. We just incorporated it using our law. So just the same with case law, they have to interpret our cases in compliance with what's been decided in the European Union.
Yeah, it's binding on those decisions are binding on our judges.
Yeah.
So that has sort of led to the vast expanse of discrimination law, indirect discrimination law, to people who haven't got a protected characteristic. That's what the courts have done, but I understand Parliament was busy too in this regard.
Yeah. So the courts made the decision, we have to comply with that legislation. It doesn't matter that it's not written into our legislation. We have to comply with that case law. So they made the decision that, yes, they could be claimants, even though they didn't have the protected characteristic. What happened in January 2024, which was actually 7 months before the British Airways case went to appeal tribunal was the changes to the Equality Act were brought in. So the Equality Act was amended to include a new section 19A, which deals with indirect discrimination, same disadvantage. So the interesting thing with that is that even though the original case was specifically relating to goods and services, and there are separate provisions in the Equality Act dealing with employment cases, dealing with goods and services, and the different rules that you have to follow, instead of just keeping it as goods and services, they've actually just implemented a new form of indirect discrimination.
Yeah, which applies across the board, goods and services and employment, is the thing that is going to impact most people's lives who are watching this. I think that, I guess one of the concerns could be from employers, we advise a lot of employers, is that we are sort of vastly expanding the opportunity that people could bring claims. Yeah. I mean, in particular, that changes to terms and conditions of employment. If you haven't got a protected characteristic, a lot of the time, as an employer wants to introduce a change. Shift pattern is the obvious one, which we've dealt with here. A shift pattern change. As an employee, you can say to your employer, well, hang on, we signed a contract. You haven't got anything in the contract that does say you can radically change my shift pattern. But you're going to do it anyway. If you haven't got a protected characteristic, historically, you would be left really stuck between a rock and a hard place, because even though a contract is a mutual agreement and one party trying to change it on their own is, unilateral fundamental amendment, which is arguably, illegal in the civil or the contractual sense. It's something that they can't do unless you agree. You are always stuck as an employee with, well, what's your remedy? And your remedy actually is to say, well, by trying to change my terms and conditions against my will, that's a unilateral change. I have therefore been constructively dismissed. Yeah. And therefore I can bring an unfair dismissal claim.
Yeah, so you'd go for unfair dismissal based on, so they've treated you in such a way that they've treated the contract as if it's ended. So it's a repudiatory breach.
A repudiatory breach of contract, quite. Now, but for a lot of employees, that's not a great option, right? Whereas historically, if you've got a protected characteristic, you could file your grievance and you could bring a discrimination claim while still being in employment.
So you could stand and sue.
Yeah.
So you're taking your employer through the employment tribunal to claim discrimination, whatever for.
Yeah.
And you can also continue to work there, and essentially the remedy that you're looking for is the declaration that it was discriminatory, and therefore that they remove the policy or that they do something to remedy that.
So, and I guess what I'm getting at now is, and that's really common, we would be advising employees and employers on these sorts of issues all the time. You are vastly potentially going to increase the number of claims.
Yeah, definitely.
And I'm mindful that we may, even over the next few days, even over the next week or so, be in a situation where, I don't quite know when it will come into force, but we're going to have day one employment law rights. Yeah. Potentially day one unfair dismissal rights. Yeah.
So discrimination is already, if you dismissed because of a discriminatory reason, that would already be automatically
You don't need a qualification period.
You don't need to have worked there for 2 years at the moment. But if the right to claim unfair dismissal is brought down to day one, it's just potentially going to encourage people to essentially give it a go.
Which, I mean, on one level you could say is fine. This is people enforcing the rights that, these hard-won rights. But I'll get the statistic wrong, but I mean, I want to say it's 500,000. Surely it can't be that many cases currently in the tribunal system. It's hundreds of thousands, whatever it is. Yeah. Regularly, from beginning a claim to it being heard, is somewhere in the region of 2 years.
Yeah, so I think what we're seeing at the moment is about 12 to 18 months. I've spoken to other people and they're saying that it's 3 years down the line and they still don't have a date for the final hearing. And that's just... the stress, obviously, for the parties, if someone's lost their job as well, that's 3 years where you're fighting a case. And yes, there's no fees in the employment tribunal, but if you did want representation,
it's costly, yeah.
It's costly, and the general cost rules are that you're unlikely to recover your costs in the tribunal.
But it's also sort of theme of this podcast that, with some interaction with the court system, and the court system a little bit sort of, and the tribunal system grinding to a halt. There's no point in having these rights if they're never going to be determined. If it's 3 years even away from 3 years from even having a date. So, you could be pushing on for 4 years sometimes before some of these claims are determined.
That's why we do see a lot of these types of claims settling, because obviously it's a cost to the employer and potentially to the employee to have these matters dragging on. And if it is going to increase the amount of claims that are coming through and increasing the backlogs with the tribunals, you might see more claims going to a settlement, whether they're right or wrong, or potentially employees settling for less than what they should get, or employers settling claims that would have otherwise been unsuccessful.
From an employer's perspective, I think they need to come and get some advice from an employment lawyer. Again, another thing that we say a lot on this podcast, to come speak to yourself, Victoria, when they are introducing something new into their terms and conditions, a new policy, a new practice, to be mindful of, whether or not it is going to trigger a potential discrimination point, right? Yeah.
And one of the main things to remember is with indirect discrimination, you do have the potential defence. So a policy is if someone is disadvantaged by that policy because of their protected characteristic, you can then put forward an objective justification. So if you can say that it's a proportionate means of achieving a legitimate aim, you've got the potential then to defend the claim. So I think there's one particular case, if I can just find the name of it. So it was a case 2013. There was a nurse called Miss Chaplin.
Right.
So it was a big case. The case is called Awida and others.
Let's keep it at Miss Chaplin, just
but
for
it's
ease
Miss Chaplin because it was a series of claimants.
Fine.
So Miss Chaplin was a qualified nurse.
Right.
And she had a necklace, a cross, that she wore because of her Christian
belief. Oh, I remember this one, yeah.
And she had usually worn it under her tunic, but the policy said that no necklaces were allowed. Any other jewellery, you could speak to your line manager and they'd see what they could do, but the necklace was a health and safety risk. She claimed that the policy was indirectly discriminatory because she was told to remove her cross. Mm-hmm. And the employer was actually successful in defending that
because of a health and safety justification. Do you know, though, what that also causes me a little bit to believe, and we saw this in the COVID period, and it all causes me a little bit of a concern, is that you can see in changes in policies and conditions, even shift patterns, right? You're running an Amazon warehouse or a coal mine, if there are any of those left, right? Or a metal bashing practice, and you need to have a certain shift pattern to meet you. And you can have the justifications for quite strict health and safety policies and all of that sort of stuff. And the employers in those industries have got those defences, and rightly have got those defences. They don't, like, if it's a sort of middle class, it seems almost discriminatory on a class system, if you like. If you're working in an office, justifying policies about crosses or changing shift hours and whether somebody can work from home or not, I don't know. There's part of me thinks that much harder to justify.
I think it can be difficult to justify, but the tribunal will consider what the reasoning was. So it's important for employers to actually make sure that they've got in writing why they need the policy in place. Mm-hmm. And set out clearly what their justifications are. So if there is a genuine business need, for example, the majority of your clients work in a time zone that's a couple of hours ahead, and so you need to make sure that you've got some people working during those hours to make sure that the calls are answered, that the clients are responded to. That could potentially be a justification. there. So it's just going through what the actual business need is and why that is the proportionate means. So it doesn't have to be the only way that they can deal with that issue, but it has to be proportionate to what the issue is.
Yeah, you can't use a sledgehammer to crack a nut. Yeah. They always used to say that when I was in law lectures. Yeah. Sledgehammers and nuts cracking in all sorts of different areas. Okay, well, I think what probably I would say is that we will put a link to the employment pages on our website below. And if anybody if there's something in this podcast that's caused you concern, or you think you might have a case, or you're an employer and you're looking to introduce some changes to how you do things, and you're worried that that could cause you some issues in relation to the discrimination legislation, please follow the link and get in touch with us, and Vicky will be